Donald Trump loses yet another case in federal court as a U.S. District Court judge barred Trump's immigration authorities from barging into churches and other places of worship to enact their immigration crackdown. Let's discuss. I'm Dave Aronberg, former state attorney for Palm Beach County, aka the Florida lawman, here on the MeidasTouch network. So this is something you're getting used to. The judges, the judiciary is pushing back against the Trump administration, a lot more so than the legislative branch. You don't see too much pushback by the folks in the U.S. Senate. The House, has anyone heard from them? Are they in the witness relocation program? But when it comes to the bench, yeah, we're seeing it. According to Newsweek, a federal judge on Monday barred immigration agents from conducting enforcement operations at houses of worship associated with Quakers and several other religious groups. U.S. District Judge Theodore Chang ruled that the Trump administration's policy might infringe on religious freedoms and should be suspended while a lawsuit challenging it is resolved. So you got a temporary injunction in place, and this judge, if you're wondering, was appointed by President Obama. But we're seeing this across the board from judges who are appointed by Democrats and Republicans alike, even judges who have been appointed by Donald Trump. Now, it's not unanimous. Trump has scored a few victories in court, but for the most part, he's lost. And he's realizing the limits of his executive authority. And in an extensive ruling by Judge Chang, for over 30 years, the United States government has imposed various limitations and safeguards on the execution of immigration enforcement actions in or near places of worship. In light of the First Amendment's protections relating to religious exercise, such limitations serve to mitigate the potential collision between the interests of government and religion that would inevitably arise from intrusions by armed law enforcement officers into churches, synagogues, mosques, temples, and other places of worship. On January 20th, 2025, the United States Department of Homeland Security, DHS, abruptly removed all such limitations and safeguards and instead left decisions on whether to conduct such enforcement actions to the unilateral discretion of individual officers. 3 different faith communities have now challenged this action. And we'll get to the decision shortly, but just to answer a question you probably are thinking, well, this will go up to the Supreme Court. What are they going to do? Well, the Supreme Court, which has granted Donald Trump powers that no other president has been granted with that immunity ruling written by Chief Justice Roberts. But when it comes to religious authority, what we've seen is the Supreme Court has taken a very expansive view of the First Amendment when it comes to religious liberty. And as such, this sets up a real confrontation between Donald Trump's attempt to expand his executive power, which the Supreme Court has, at least in some rulings, has approved of, and the First Amendment right to the free exercise of your religion. Well, which is going to give? Both. The free exercise clause of the First Amendment has been strengthened by this Supreme Court, the Roberts Supreme Court, as well as a president's executive power. So it's not so clear which way it's going to go, especially when you have someone who's deeply religious, like Justice Amy Coney Barrett, who is known as a very solid pro-religion, pro-free exercise vote on the court. That sets the stage for a very close vote if it gets to the Supreme Court. But for now, ICE and Kristi Noem and Donald Trump are not going to be allowed to go into places of worship to remove people as part of their immigration crackdown, at least not the plaintiffs in this lawsuit. A big reason for the judge's ruling is that the judge cites on page 38 of the opinion that the 2025 policy will significantly affect plaintiffs' expressive association by removing any meaningful limitations on intrusions into places of worship by armed law enforcement officers. The Quaker plaintiffs have attested that pacifism is deeply ingrained in the Quaker faith, such that having weapons or armed people in or around the meeting is inconceivable and contrary to our faith. Reuben Moore, the clerk of the Green Street meeting within the Philadelphia yearly meeting, has stated that many people choose to join the meeting because of this commitment to nonviolence and because they understand that Quaker meetings are a place of peace and nonviolence. Indeed, because Quaker worship requires sitting quietly, releasing distractions, and reaching an inner stillness that leads to spirit-led listening. The idea of there being weapons at meeting is distressing enough to make it very difficult to engage in waiting worship and will discourage attendance. Even now, and as attested to by Roni Kingsley, the clerk of the Richmond Friends meeting, the knowledge that ICE agents can interrupt our worship is already making our members less likely to attend. I mean, they've got a point. If you're a Quaker and you're committed to pacifism and nonviolence and peace, it does interrupt your free exercise of religion, knowing there's going to be armed guards rolling in there at any moment. And I realize that that could butt heads with the executive order on ICE, but then again, these are executive orders, and perhaps then you need legislation to carry out these things when they are in conflict with constitutional rights. And even legislation may not be enough to overcome the balancing test that you need here for the free exercise of religion versus the need for secure borders. And as far as that government interest, well, the court addressed it and concluded that even assuming that the government could establish the requisite compelling state interest, the court finds that on the present record, the 2025 policy cannot be deemed to meet the second requirement that the asserted state interest cannot be achieved through means significantly less restrictive of associational freedom. So what they're saying is, if you want to go ahead with your immigration crackdown, you can do so, but you can't barge into churches without their permission like that. You're disturbing their right to worship. It's got to be a less intrusive means to go about it. This is not the least intrusive means. And there are ways to do this without going guns a-blazing into a house of worship. And in this case, like other cases we've seen, the words coming from the administration's mouthpieces are being used against them. Kristi Noem's words, Donald Trump's words, all their bluster about immigration and cracking down on undocumented migrants, that is coming back to haunt them in federal court, because the court here says that, moreover, as discussed in the court's analysis of plaintiff's First Amendment claim, it is reasonable to expect that such enforcement actions will occur at plaintiff's places of worship where DHS, Department of Homeland Security, specifically stated in its press release announcing the 2025 policy that criminals will no longer be able to hide in America's schools and churches to avoid arrest. Uh-oh, you just admitted it right there. You just said that we're going after you in the churches. So it's not like this is just an offshoot of a policy. This is like we have a policy aim, and this is just an inadvertent or a collateral damage here. This is the policy. The policy is to go in the churches and drag people out. And the court said, yeah, you said that you were going to do it. You could do it without such intrusion. And it can't be like, well, that's not our intent. Our intent is elsewhere. And this is just, a side effect. No, it's not a side effect. This is the main policy goal. This is what you said in your own statements. And as far as the pretty drastic remedy of issuing an injunction before the merits of the case have been decided, well, the court addressed that, saying that the facts on the record further demonstrate that these factors favor an injunction. Plaintiffs have provided evidence that the willingness of their congregants to attend worship and participate in ministry services is presently being chilled, and that, particularly at CBF and the Sikh Temple, attendance at such activities has already declined. Plaintiffs have thus shown that religious exercise is being hindered by the 2025 policy for entire congregations, including United States citizens and immigrants with legal status, whose ability to worship is undermined by such reduced participation. In contrast, DHS, Department of Homeland Security, has provided no facts demonstrating how its interests in increased immigration enforcement or otherwise would be materially and adversely impacted by an injunction, particularly one that would serve to pause the rescission of the 2021 policy, as it has identified no necessary enforcement operations that could not be accomplished within the framework of the 2021 policy. The policy that President Biden implemented, or that cannot be accomplished without intruding on plaintiffs' places of worship. The court therefore finds that the balance of the equities and the public interest weigh in plaintiffs' favor. So that's why this judge did what he did, and it was a pretty thorough analysis, 59 pages. And, looking through it, the judge here said that you could have done this with less restrictive means. You made it clear this is what your intent was. There's First Amendment concerns. And you are being overbroad. You are going in there guns a-blazing, dragging people out. And that is hurting people who have a legitimate right to be there. You are inhibiting their free exercise of religion. Even if you do catch people who are undocumented there, you are also intruding upon the rights of people who are legally there, who are citizens or are on legal status. And that is an overbroad way of enforcing our immigration laws, which you could do in a more narrowly tailored way than just raiding churches and mosques and synagogues and Sikh temples and all these other places. So this is where it is on immigration policy. And as far as whether we're seeing mass deportations like President Trump promised, well, actually, the results are different. According to Reuters, Trump is deporting people at a slower rate than Biden's last year in office. Facts matter. Don't believe the hype. And we'll keep dishing the facts here on the MeidasTouch Network. I'm Dave Aronberg, aka the Florida Lawman. If you like this video, please like, subscribe, share with a friend, and leave a comment below. And check out our sister channel, Court Authorities, where we meet at the intersection of law, politics, and true crime. I do a lot of videos over there. It's an affiliate of the MeidasTouch Network, Court Authorities on YouTube. I'll see you there. And I'll also see you here next time.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.